Hi, this is Vivian Dempsey and the Writing Edge. I'm going to be discussing question 5 from the summer 2013 bar exam, which was a wills question. In fact, there were no trust issues in it, just a wills question. In this one, Ted writes a document in the year 2000, and it is a typed document. He intends it to be his will, and he gets two people together to witness it. And he says, I already signed it, that's my signature, this is my will. That attestation of his signature is sufficient. One witness signs and the other witness is called away on an emergency and the next day signs. This is not proper procedure for a formal will. The witnesses have to sign in each other's presence at the same time. And so the 2000 document, which Ted intends as his will, is not a valid will. In 2011, Ted writes a note. He doesn't intend it to be his will. And in the note, he says, in my will that I wrote in the year 2000, wife refers to my current wife, not the person I was married to then. My current wife is Bertha. And he intends that just to be a codicil to the 2000 document. However, the 2000 document is not a will. So you can't have a codicil to something that isn't a will. So is there another interpretation? The other interpretation is that the note in 2011 is the will. It's written in Ted's handwriting, so it's a holographic will, all in his handwriting, all material provisions in his handwriting, and signed by him. Now, the material provisions aren't in the note because he's referring back to what he wrote in the year 2000. So that's a problem. But now that this is the will, he can refer to the 2000 document and incorporate it by reference. Now, there might be a slight problem, and reasoning might be a good idea here, because although the wording of the 2000 document doesn't have to change, wife meant something different in the 2000 document than it means now. And the whole theory behind the incorporation by reference is that it's valid without meeting the formalities of a will because it existed in just that form at the time that it was incorporated into the 2011 will. Because all he said in the 2000 document was wife, it is being used exactly as it was written. And so I think that overcomes the incorporation by reference problem, and the 2000 will is going to be incorporated by reference into the 2011 will. So that works. Now, when we're looking at the 2011 will, it now says all my community property to my wife. Well, what does that mean? Now we can use another rule of interpretation called documents or acts of independent significance to find out what wife means. Okay? We can look at the county death records to find out that the first wife died, and we can look at the county marriage records to determine that Ted's wife in 2011 was in fact Bertha. So through incorporation by reference and documents of independent significance, we can come up with the interpretation of the 2011 will. That takes care of the main problems with this will. Then the question asks who gets what. And half the community property goes to his wife, that's Bertha, $300,000. The son gets $10,000, and $10,000 goes to friend Dot. Now, in the 2000 document, Dot witnessed the will, and if it was the 2000 document that was being submitted to probate, Dot would be an interested witness and would be unable to overcome that presumption. However, because Dot is not a witness to the 2011 will, no problem, and Dot will take the $10,000 gift to her. The residue goes to the daughter Cindy and that would be $280,000. And that's the solution to this test.